Okay. Hi, everyone, and welcome. My name is Yasmin Yavar, and I am a senior staff attorney at the Children's Immigration Law Academy, or CILA. We're a project of the American Bar Association located here in Houston, Texas. I'm joined today by David Walding, director of the Bernardo Kohler Center, who is presenting today from Austin, as well as Dalia Castillo-Granados, CILA's director, who's here in Houston with me. Our topic today is post-18 issues in Texas state courts and before USCIS. CLE credit is available for this webinar for 1 participatory hour. And if you provided your bar number upon registration with ReadyTalk, then we'll submit your participation to the state bar. And I know sometimes folks like to watch on one computer if they're in an office. Just let us know you attended by sending an email to CILA@abacila.org if you do that, or go ahead and self-report to the state bar. Okay, so our presentation today is going to cover 5 broad topics. I will discuss the procedural framework in which we are operating in filing applications with and receiving notices from CIS. Next, David Walding will discuss the Budhathoki litigation and USCIS's response in the wake of the decision by the Western District of Texas Federal Court in Budhathoki. And Dalia will conclude the presentation by offering state court guidance in light of CIS's current posture in post-18 cases. She will also discuss specific issues relating to post-18 declaratory judgments. Feel free to write in questions at any point during the presentation. Brandon's going to be monitoring the questions, and we will have time at the conclusion to address questions as well. Okay, so let's just start by defining what we mean when we say a post-18 SIJ case. And what we don't mean. So we're really talking about a case in which the state court order submitted with the I-360 was obtained after the child turned 18 years old. The case could have been initiated before or after the child turned 18, but the order was not entered until after the child turned 18. And the order may be one that you obtain in a SACPR proceeding or through a declaratory action. What we're not talking about is cases where the order was entered before the child turned 18, but the I-360 wasn't filed or adjudicated until after the child turned 18, because those cases, of course, are protected by the Paris-Solano stipulated agreement. Okay, let's talk briefly about possible outcomes upon the initial filing of an I-360. And so you see here the different rectangles. The first possibility is approval, right? And I think we began seeing notices of intent to deny in these cases in Texas many years back. I think the first ones were seen in El Paso. At this point, I don't really know of any jurisdiction in Texas where folks are still seeing approvals of the post-18 I-360s by CIS. We're now aware of denials here at CILA from the Houston area, the Harlingen area, the Austin, San Antonio, and Dallas areas, in addition to El Paso. CIS could, per the regulations, issue a request for evidence in one of these cases or a notice of intent to deny, right, the RFEs and NOIDs. The petitioner could also withdraw or abandon a filed I-360, or CIS could outright deny an I-360 without issuing any RFE or NOID. That's not something we've seen. Typically, CIS is going to issue some sort of notice, an RFE or NOID. If you look at the relevant regulations at 103.2b8, it seems like where CIS is taking issue specifically with the fact that your client was over 18 at the time the order was entered, you're likely to receive a NOID rather than an RFE, right? Because you've submitted all the required evidence, but per CIS, the evidence doesn't establish eligibility. Okay. Where we're seeing a lot of activity in these cases right now is actually after approval of the I-360, right? So many of you have cases where the I-360 was approved without issue, and now months have passed, maybe longer, and you're receiving notices from CIS about the case. The key words here are revocation and rescission, and at least for me, it can be hard to keep them straight. So revocation relates to the I-360, right? INA at Section 205 provides that the Secretary of Homeland Security may, at any time, for what he deems to be good and sufficient cause, revoke the approval of any petition approved by him under Section 204. Such revocation shall be effective as of the date of approval of the petition. And just FYI, 204 of the INA relates to family and employment-based petitions, including SIJ petitions. So we're now seeing CIS move to revoke previously approved I-360s in the post-18 cases. Revocation efforts have been seen in cases where the underlying order was a declaratory judgment as well as a SACPR order. And the relevant regulations are at 205.2, 8 CFR 205.2, for revocation on notice, which should be distinguished from 205.1, which are the regulations relating to automatic revocation. You have automatic revocation provisions for SIJ, you guys probably remember, like marrying prior to adjusting. But that's not where these revocation notices are coming from. They're coming from 205.2, which provides that any service officer authorized to approve a petition under Section 204 of the Act may revoke the approval of that petition upon notice to the petitioner on any ground other than those specified in the automatic revocation provisions. The key here to note is that there is no time limit provided by the revocation statute or regulation as to when the service can revoke. Okay, now looking at rescission, right? Say you get your I-485 approved, but then you're facing possible rescission. So rescission really relates to the adjustment of status in the 485. And INA Section 246 provides that if at any time within 5 years after the status of a person has been otherwise adjusted, it shall appear to the satisfaction of the AG that the person was not in fact eligible for such adjustment, then the AG shall rescind the action taken. So far, we've only seen one case in which CIS has approved an SIJ-based 485 and then moved to rescind the 485, and that's a case out of Houston. It was actually set before Immigration Judge Harris today for a rescission hearing this morning, but that was continued until February 15th, so unfortunately we don't have more of an update there. One thing to note is that the standard for rescission of the 485 is a high one. That's the good news. And we'll discuss that a little bit more on the next slide. Now here at CILA, when we looked at the relevant statutes and regulations on revocation and rescission, we wondered how the two provisions related, right? The I-360 revocation provisions talk about at any time, and the the I-360 revocation provisions talk about at any time, and the I-485 rescission provisions talk about within 5 years. So I think we sort of figured it out, right? If your client, your SIJ client has adjusted, he or she could still be subject to removal proceedings even if 5 years have passed and he or she is no longer subject to rescission proceedings. And that's because of Section 205 of the INA allowing for revocation at any time. That applies to petitions approved under Section 204. Section 204 includes family-based and employment-based visas like the SIJ visas, which, as you all know, fall under the EB4 employment-based category. Section 246 of the INA, providing that 5-year limit, applies to any adjustment of status, but is not limited to those obtained through a family or employment-based visa. So think VAW was used to use cancellation of removal. All that to say, that's why this last rectangle appears on your slide. Even after 5 years, you could still be subject to removal proceedings in lieu of rescission. And all that to say, you're really not completely safe until your client becomes a U.S. citizen. Again, not to set off any alarm bells, we haven't seen many rescission cases, just the one here in Houston, but we have seen a lot of notices of intent to revoke and revocation of the I-360. Okay. And just this last slide is on remedies for denials, revocations, and rescissions. Let's just talk briefly about what happens after each of those, right? After a denial, you can file a motion to reopen or reconsider. An appeal is going to go to the Administrative Appeals Office, or AAO, and I've cited the relevant regulations for you. You know that the Form I-290B would work for the reopening, the reconsideration, the appeal, and it has to be submitted within 30 days after service of the denial. I've also cited the statutory authority for you on an appeal directly to the federal district court, bypassing the AAO. As far as revocation of the I-360, on revocation, there have been notices to revoke instructing the party to file the appeal with the BIA, and that's not correct. So we found several AAO decisions on revocation indicating appeals of revoked I-360s lie with the AAO. So just a word of caution, watch out for notices from CIS that indicate you have 30 days to respond. Although you could make an argument based on their incorrect instructions, that it's their fault, they gave you incorrect instructions. The proper timeline is actually 15 days. That's at 8 CFR 205.2. And the proper appellate body, again, is the AAO. As for rescission, the remedy is a hearing before an immigration judge. And as previously mentioned, the standard for rescission of an I-485 is a high one. In rescission proceedings, the government bears the burden of proving ineligibility for adjustment of status by clear, unequivocal, and convincing evidence. And that's eligibility at the time the adjustment was actually granted. For many of the cases we've reviewed, there was fraud or some misrepresentation, and that's why the rescission was ultimately granted. We can argue in our cases, if we have to, right, that there was no fraud or misrepresentation. The court and CIS knew the person's age. With that procedural framework in mind, I'm going to go ahead and turn it over to David now. David?
Yes, hi. Can everyone hear me okay? Okay.
We can hear you.
Great. So I wanted to just briefly go over a little bit of the history that brought us to the Budhathoki litigation and where we are and what we've kind of done to address it. So I'll try to, keep it concise, and if there's any questions, I'm happy to answer them. If you type it in, we can address them. But essentially, we at the Bernardo Kohler Center have done quite a few of these, and we were not having any issues in our area until end of 2013, which is when the San Antonio District Office seemed to just stop processing. So we weren't getting denials, but we were getting 1.5, 2-year delayed decisions on the I-360s. Sometime in 2015, I believe it was, the San Antonio District Office started generating the decisions and approving our under 18 but denying most but not all of our post-18 cases. And I will say, Yasmin, we've gotten an approval out of San Antonio as recently as December, so we still do get the occasional approval. It's not across the board, but it's the vast majority are now being denied. And so we took those appeals back in 2015 to the filed appeals on a lot of those cases to the Administrative Appeals Office. Didn't get any decision or any movement from the AAO. We tried to expedite, we tried oral argument, we tried, to get some precedent decisions out of them. The AAO just sat on everything. And so late last year we decided to, 3 of our clients elected to go forward without filing an AAO appeal to make the San Antonio decision final, and challenged that in federal court under the Administrative Procedures Act. And Budhathoki is the lead plaintiff in that challenge. From there, what happened in the Budhathoki litigation is that it went before Judge Sparks in Austin Federal Court. We originally had 3 plaintiffs. One of the plaintiffs they actually reopened the sua sponte and granted his I-360 to moot out those claims. We had a 3rd plaintiff then join back in, so we're still at 3 lead plaintiffs, but one of the plaintiffs was granted, and I'll address that in a second. And the others went forward before Judge Sparks. The government filed a motion to dismiss, as is normal in these types of cases. We had a lot of back and forth with the government where they kept proposing new and different reasons why they said CIS had ultimately denied the I-360s and were correct. And every time we would respond to one reason, they would come up with a different reason. Judge Sparks set it for oral argument on everything. So all pending motions, the motion to dismiss, there was a motion for class certification. However, we were prepping for the oral argument, and 2 days before oral argument, he granted the government's motion to dismiss and issued an order, which I don't know if everyone has seen, but it is public, so people can look at it. I don't know if it's been distributed, but the order dismissing came from Judge Sparks in Austin. We have now appealed that dismissal to the Fifth Circuit. So right now it's before the Fifth Circuit Court of Appeals. It has been set for a briefing schedule. Our brief is currently on February 22nd. I was just told yesterday that the judge is actually going to extend that by 20 days. So now our brief will be due sometime in mid-March. We don't know the exact date yet, but we should have it briefed sometime before the middle of March anyway. So the second week of March is going to be due. So with that said, I'm a little bit limited in what I can say about all of the arguments, but it is before the Fifth Circuit. We have reviewed it. Texas Rio Grande Legal Aid has joined on the Fifth Circuit appeal, and we believe we have fairly strong arguments. We believe we should prevail. Of course, it's the Fifth Circuit, so you're never quite sure what you're going to get at the Fifth Circuit on these cases. But essentially, if you read Sparks' decision, there's quite a few errors in the way he handled the dismissal, and it was actually, in our opinion, not the correct order. However, I do understand that from there, USCIS and especially Houston, I've seen a couple of the, I think it's a notice of intent to deny, Dalia, maybe, that are citing now to the Budhathoki decision. I haven't seen that in San Antonio, but I've definitely seen that now out of Austin. And I know Dalia sent me the language so that I could kind of address that language as well and why CIS also kind of has it wrong. So what the Budhathoki litigation is and what it is not, I wanted to kind of clarify, because we've had a lot of people asking us, you know, what's up with the class action, and does my client qualify, and is it covered, and what do I have to do? So there's a few things there. We did file in Austin for class certification, but as part of the order dismissing the case, Judge Sparks dismissed and denied all of the pending motions. That included the motion for class certification. So there was never a class certified. There is no class. So the Budhathoki appeal only pertains at this point to those three named plaintiffs. It does not apply to anyone else. And certainly that could change if we're successful at the Fifth Circuit and it's remanded. Then the class could be taken up again, but at this point it's only applying to the named plaintiffs. It also does not apply to declaratory judgments. It's specific to orders under Title V of the Texas Family Code. So if you have a declaratory judgment order under the Civil Practice and Remedies Code, that's not contemplated per se in the Budhathoki litigation either, although some of the arguments at the Fifth Circuit will overlap and apply to both. But the plaintiffs themselves were not, they were all post-18 SACPR orders, so suit affecting parent-child relationship cases. The other thing it does not include, which is I mentioned that we had one client that was reopened and granted, is occasionally we have SACPR cases in certain counties, and it seems to vary from county to county, where if you have filed the SACPR petition before the 18th birthday, or sometimes even after the 18th birthday, depending on the judge, as long as they're remaining in high school and remaining under that SACPR jurisdiction, the judge feels obligated or compelled, and certainly having the authority to provide conservatorship orders as well. The justification we've been hearing from the judges is that if the person is a child, which they are under the family code, and they're ordering support for the child, then somebody needs to be taking care of them, and the money should be going to that responsible adult, not the payments going directly to a child. So many of our cases, although not the majority, but some have had conservatorship orders. The one case that was reopened and granted from our original pleadings had conservatorship orders in the SACPR order. So the government did stipulate that if that's the case and there is conservatorship, then those cases should be valid for SIJ, and they would grant that. I have two other cases that were both denied with conservatorship orders. There was another attorney in San Antonio with the same thing, a conservatorship order for Post-18, and his was denied. Mine are before the AAO, and the AAO has not ruled on that, even though it's been a year and a half. However, the attorney in San Antonio I'm aware of filed a separate APA claim, and they likewise reopened and granted the I-360 for that case. So the basic argument from USCIS, is, as much as I can decipher it because they're a little bit schizophrenic, is that in order for a court to be acting in the capacity of a juvenile court, they must have the authority to issue both care and custody determinations. And if your order only obtained child support, while that might be care of a child, it's not custody of a child, and therefore there's no evidence in your order that they're doing both or can do both. So therefore it's not acting as a juvenile court, and therefore it's not valid for SIJ. And I know that was a long way to get to the explanation, but that's about as concise as I can be in their reasoning, as well as I understand it. So that is the essential issue that we have ultimately in the Budhathoki litigation is this a juvenile court? And if so, what are the requirements for the standard for the SIJ language in these orders? The government issued in Sparks' order says there needs to be an explicit declaration that the child is dependent on the court, which in my mind did not square with the matter of Menkivar decision. But that's what Judge Sparks says, so now that's something that I know USCIS has latched onto. They also seem to say from the AAO perspective that child support, there was no evidence that child support was intended for the care of the child. And so we've had to clarify that as well. So what we've done on our half is, going forward, we have some additional findings that we're adding into our SACPR orders. For the ones who already had existing SACPR orders in Travis County, at least, we've been able to do a motion to clarify, which adds these additional findings and addresses the Sparks decision in a motion to clarify, saying at the time we issued our SACPR order, yes, they were a child. Yes, we ordered child support for the care of the child. and yes, they were dependent on the court. I have gotten a couple of cases now granted with that clarification order out of San Antonio. I have yet to get anything from Missouri Service Center, however. So either with an pre-existing, like an all-in-one order, or with a motion to clarify, I've not gotten anything yet of any sort, approval or denial, out of Missouri Service Center. So I'm not sure what the Missouri Service Center is going to do. The AAO is taking the position that if they're not, that it has to be custody. If there's not a custody order, then it's not acting as a juvenile court. So I think in the Budhathoki litigation, that's part of the crux of our argument and our appeal is, one, what is a juvenile court? Two, who decides if it's a juvenile court? Three, does it have to be both care and custody, or is it one or the other to qualify? And what does it exactly mean to be dependent? Those are all things that are going to be kind of tied up in that litigation, which is why I say there will be some overlap into the declaratory judgments. However, the decisions in those cases were older decisions before they've refined some of these arguments. So our main argument, I believe, at the Fifth Circuit is going to be pretty straightforward in that the court can only review what USCIS originally put in their denial. And their denial was they're not children because they're over 18, and therefore they're not dependent on the court, and it's not a valid SACPR order. At a minimum, the AAO has said, yes, they are clearly children under the family code. It doesn't matter that they're over 18. If they fit the definition of child, they are children. And two, that they haven't questioned the validity of the order itself. So they're saying the orders are valid and they are children. They're just saying that they're not acting as a juvenile court. That's the current AAO position. And I was going to address very quickly, again, I'm trying to keep it short, but the NOID that Dalia sent me out of Houston, which cites to Budhathoki because it's not accurate. So essentially what it says that Judge Sparks said is that they were properly denied, and that's not exactly what it said in the Sparks order. It says USCIS did not exceed its authority in denying the SIJ application since the court did not provide a reasonable basis for their jurisdiction and dependency findings. Well, that's not exactly true. It's part of what's on appeal because in order for the judge to reach that conclusion, he had to accept and consider documents that were filed on behalf of the government, yet ignore all of the documents considered by the plaintiffs. And we don't believe that's an appropriate standard, so either he has to accept everything or accept nothing. So he basically took the government's documents at face value, and anything that we had that contradicted the government documents he ignored. The reasonable factual basis is actually a language that's derived out of the consent clause, and none of this has anything to do with the consent clause. They were not denied by withholding of consent. So that's another thing that we're going to have to address at the Fifth Circuit. And it says USCIS is unable to determine the Texas court's basis for jurisdiction under Texas law. Well, that's blatantly wrong because it cites to the SACPR child support statute and gives the basis for its jurisdiction. And as I said, the AAO even agrees that it's valid and jurisdiction was proper. So it just, the NOID takes, again, it's this misunderstanding and perversion of what the SACPR orders say, and it just kind of makes it, it's what's made it really difficult to combat, is they keep coming up with these things in their decisions or in their arguments that are just not grounded in the actual family code. It also says the court did not assert its jurisdiction over the petitioner as a child under Texas law. That's also not true. It clearly did assert its jurisdiction over the petitioner as a child. It's in our orders. It's, I'm assuming, would be inherent in any SACPR order. If they're not a child, they're not subject to a SACPR order. And it's clear in Texas law that they are considered a child. And again, the AAO has conceded that point on our cases. So the AAO conceded a lot of these issues that are on appeal, even when denying our cases at the AAO after the Judge Sparks ruling. They still conceded most of these issues. So that's why we're going to have to figure out a way at the Fifth Circuit now to present that to them, because it really undercuts the Sparks order. Even though they're denials out of the AAO, they concede those issues. So I'm happy to help out people who have questions if I can be of any help. I think USCIS and the AAO are going to dig in at this point. I've been told by USCIS in San Antonio that they are instructed from higher up simply to deny any and all post-18 at this stage and let the courts sort it out, is what they've told me. So I think that's kind of the posture that we're in right now. We would hope to be able to finish up the briefing in Budhathoki in March, and hopefully the Fifth Circuit will decide. Thanks. I'll turn it back over to you now, Yasmin.
Thanks, David. This is Dalia, and I'm trying to read here. There's a couple of questions that came through. Let's see. There was a question earlier about whether, you said that Budhathoki doesn't apply to declaratory judgment cases. So does that mean that it's more likely that the I-360 will be granted if there is a declaratory judgment? I think I'm going to address declaratory judgments a little bit later in the presentation, but do you have any thoughts on declaratory judgments, David?
We normally don't do declaratory judgments. It's very rare in kind of unique circumstances, so I'm probably not the best person to answer that question. But essentially, no. I think the declaratory judgments are on definitely no better grounds, probably a little bit worse, because the issue with the Civil Practice and Remedies Code is it does have a strict 18 cutoff for the definition of child. So it's hard to say that a 19 or 20-year-old is a child under the Civil Practice and Remedies Code. Whereas they are considered a child under the Family Code if they're still enrolled in the high school program, which is why we've elected normally to go with the SACPR and the Family Code. However, I think part of the issue that's rolled up into this is, does that even matter? Because it says juvenile, not child. Is that equivalent? I mean, these are kind of gray areas that I'm not sure we have an exact answer for. One of the things we'll have to be challenging as well is a Texas district court is clearly a juvenile court under the federal definition, and the whole acting in the capacity of standard, is that even allowable in for USCIS to then make that additional requirement that they be acting in the capacity of a juvenile court? If the answer to that is no, then declaratory judgments and SACPRs will be kind of the same going forward because a district court is a juvenile court. If the answer is yes, they have to be acting in the capacity of juvenile court, then that's where I think the SACPR is better positioned than a declaratory judgment.
Thanks, David. And then we had a second question. If somebody obtained a child support order that did not have any custody award, would you recommend that they go back to state court to try to get custody? And then,
well,
okay, go ahead.
I have not seen them deny under 18 cases that only have child support and not custody. Based on the logic that they've been, espousing on these cases, that doesn't make any sense either. It seems to be relatively arbitrary and capricious. However, I think if they're over 18 and you can get a custody order, I think you should prevail. If they're under 18, I don't think it matters to USCIS, but since they've started doing these revocations, I think you'd be safer if you did.
Okay. And then, for a notice of intent to deny, you only have, 30 days to respond. So do you think it's worth it to respond to the NOID when there's such a time crunch, or is there a better chance of appealing at the AAO level with an amended state court order potentially?
You can submit new evidence at the AAO. I don't know strategically which is better. I mean, you need to respond to the NOID, though, because if you don't, they can deem it abandoned. And if they deem it abandoned, I think that makes it an extremely different appeal. So I would recommend responding to the NOID with something, even if it's just to say you're wrong and we're right and here's why, and you don't even have any additional evidence at that point. I would still respond to the NOID so that they don't deem it abandoned. They've tried to do that on a couple of my cases where I did respond and they just said, oh, we never got it and deemed it abandoned, and I had to actually reopen the abandonment decision so that they could deny it on other grounds so that I could appeal that to the AAO. So I'm not sure. I think the AAO is not going to grant you no matter what you do on a post-18 case out of Texas. So if it were me, I would suggest filing it with your district office. Because, again, I don't know what the Missouri Service Center will do, but I know that I have gotten them approved in San Antonio with those subsequent state court orders. So I think you're better off trying it at your local district office, although, again, there's no guarantee.
Great. Thank you, David. So I'm going to switch gears now and do my portion of the presentation. But, David, if you could just stay on the line, and we'll see if we have any more questions. If people have questions, you can type it into the chat box, or you could wait until the end. We've added a half hour towards the end of the presentation just for questions. So if you have questions, you can do it then.
Okay, thanks, Dalia. I'll be here.
Thanks. Okay, so let's see. We're gonna switch gears, like I said, and move on to some state court guidance. Of course, just a word of caution from this state court guidance really comes from reading Budhathoki really carefully, and then all of the NOIDs and RFEs that we've been seeing. We've been trying to offer technical assistance on those, and this is the best advice that we can come up with, but that doesn't mean that, we're going to prevail in the end. So just a word of caution on that before we start. One of the overriding themes in the new USCIS policy manual on SIJ, of course, is that the state court order should be based on state law and procedures. Now, that's true for any SIJ case, whether it's post-18 or not. All arguments should be made to the state court judge under state law, and you shouldn't cite to the INA or the regulations in the state court pleadings. We've seen a lot of RFEs and NOIDs and denials that do say that state court orders are citing to the INA. I know that was, common practice before, but now that this new USCIS policy manual has come out, we know that USCIS does not want you to do that. So if you do have templates or samples that cite to the INA or the regulations, then you should go back and scrub them to try to comply with this new guidance. So we know what the SIJ eligibility requirements are. The ones that we're going to focus on today with regard to post-18 cases is the juvenile court order with the required findings. For post-18 case, it seems like the focus for USCIS in contesting eligibility has been whether the applicant is dependent on the court, and then also whether the court order is valid for SIJ purposes. So in other words, was that court order properly issued under the state law's jurisdiction? And if so, was that child dependent on the court under some provision of state law? And like I said, before we move on, I just want to make it really clear that, we're trying to come up with the best argument under state law, but USCIS in the end may not agree, with the court's reasoning, because they are questioning the order in terms of eligibility. So if you're going to pursue a post-18 case, then we just recommend that you clearly discuss the possibility of a denial with your client, given the climate at this point. So what do we know about, this requirement that the state court order or the juvenile court order be, valid or a qualifying order? We know from the regulations that a juvenile court is defined, and it means a court located in the U.S. having jurisdiction under state law to make judicial determinations about the custody and care of juveniles. From the USCIS policy manual, USCIS interprets that the juvenile court order must have been properly issued under state law to be valid for purposes of establishing eligibility for SIJ classification, and this includes the need for the juvenile court to follow their state laws on jurisdiction. And they give an example here, and it's a post-18 example, of course. So they say that that a juvenile court may not be able to take jurisdiction and issue a dependency or custody order for a juvenile who's 18 years of age or older, even though we all know the juvenile may apply for SIJ status up to age 21. And then from Budhathoki, USCIS reasoned that since the plaintiffs were over 18 years old, they were not juveniles under Texas law. Therefore, the Texas courts were not making determinations about the custody and care of juveniles and could not be considered juvenile courts. I don't think Judge Sparks bought this argument in Budhathoki, but he did say that the SACPR orders didn't assert jurisdiction over the plaintiffs as children, as defined by 101.003B of the Texas Family Code, which pertains to child support orders. In turn, this is for a SACPR case, right, a suit affecting parent-child relationship. What is a child? Obviously, USCIS says juvenile. There is no definition of juvenile under the Texas Family Code, so we really have to look at the definition of child. You can look at the provisions at 101.003A and B. A has to do with the definition of a child. It's a definition of a child, and it's defined as a person under 18 years of age who is not and has not been married or who has not had the disabilities of minority removed for general purposes. And then provision at B is in the context of child support. A child can include a person over 18 years of age for whom a person may be obligated to pay child support. And then whether or not that court has jurisdiction over that person as a child really can be seen in two ways. It could be either custody or dependency. So if if you can get a custody order for somebody over 18, then you should. Of course, you have to argue to the state court judge that you're using the definition not at A, but at B, and the state court may or may not agree with that reasoning. But remember, you have to make that argument to the state court judge, not to USCIS. And then if you can't get a custody order, but you have to rely on dependency, then you can look at the provisions at 154, which is for child support, or potentially, this is just an idea, you could look at 160, which is paternity, and because you can get a paternity adjudication even after 18. And then to the second kind of prong, at least that Judge Sparks brings up in Budhathoki, is dependency. And I think, like David said, USCIS has picked up on this issue as well. So not only, are they juveniles, but were they dependent on the juvenile court? So at 204.11 of 8 CFR, we see that USCIS, or that a declaration of dependency has to be in accordance with state law. We have, of course, matter of Menjivar, which, kind of ties dependency to jurisdiction. But again, it does say jurisdiction over the custody of a child by a juvenile court when the child's parents have effectively relinquished control. So if you're trying to make an argument for dependency based on matter of Menjivar, just remember that there's some additional language there. It's not just acceptance of jurisdiction. We also, like David said, think that USCIS is trying to equate dependency to some sort of placement or custody. And we see this in Form I-360 where it requires or asks that you provide the name of the state agency, department, or court-appointed organization or individual with which you are placed. So USCIS does seem to be making the argument that there's this requirement for a placement or for some sort of custody determination. We also see at the USCIS policy manual that there is no real additional guidance on what dependency means. The only explanation is this example that they give in a footnote, which says that dependency is, for example, state law governing declarations of dependency, such as what's under California Welfare and Institutions Code Section 300. And then going back to Budhathoki, USCIS makes the argument that dependency is recognized under state law, Texas law, as a type of custody proceeding. Again, I don't know that Judge Sparks necessarily bought that argument, but he does say that the SACPR orders didn't identify any statutory or legal authority under Texas law that supports the finding that child support establishes dependency. So what are the ideas for trying to make an argument that that a child, whether under 18 or over 18, is dependent on the court? You can try to cite to a specific state statute, say something like the child is dependent on the court pursuant to the court's authority under Texas Family Code, and then cite the statute, whether for post-18 cases, whether it be child support under Section 154 or paternity under Section 160. You could also try to make a common usage argument. So there's Texas case law that says that if a statute is clear and unambiguous, we must apply its words according to their common meaning. At Texas Government Code 24.601B, there is that explanation that a family district court has primary responsibility for cases involving family law matters, and these matters include dependency, but it doesn't further give any explanation to what dependency means. So since the statute is clear, then we can apply its common meaning. If you look at the Black's Law Dictionary, you'll see that somebody who's dependent is somebody who relies on another for support. So you can try to make that argument. And then finally, you can also potentially make an equity argument. So the first language here comes from the Supreme Court of Massachusetts. It's not a Texas state law case, but basically what it says is that if the court if the child can say that he was abused, abandoned, or neglected by one or both parents, then it follows that the child is dependent on the court for the opportunity to obtain relief. So at the Texas Government Code 24.008, you'll see that it says that the district court may hear and determine any cause that is cognizable by courts of law or equity and may grant any relief that could be granted by either courts of law or equity. So if you use that equity jurisdiction argument, you may be able to make an argument before the state court. Now, again, all of these arguments are arguments that you have to make to the state court judge. If they agree with you, then you can put that language in the order and hopefully use it to then file the I-360. So these are not arguments that you will be making to USCIS, but to the state court judge, and they have to agree with your arguments, of course. So post-18 declaratory judgments. Unfortunately, we don't have a lot of positive, advice. We have answered quite a few technical assistance requests for RFEs, for noise, for denial on post-18 declaratory judgments, and as David mentioned, USCIS does not seem to be buying them. So we did write them out here for you. The first argument is really that USCIS is exceeding its authority. Like David mentioned, they're saying that the court must act as a juvenile court, which is really above and beyond what's in the regulations. But also, USCIS seems to be trying to supplant the state court judge's determination of jurisdiction as a juvenile court and their determination of dependency with its own interpretation of state law. And sometimes USCIS confuses this, argument that it should be a valid state court order with its consent function, which is actually what Judge Sparks did also in Budhathoki. But under the consent function, UIS can review the order to determine whether there's a factual basis for the underlying finding, but their consent function doesn't allow them to re-adjudicate threshold issues like jurisdiction or dependency. And in this case, USCIS doesn't question whether the state court had all the relevant information, but questions whether the state court had the power under Texas law to make its determination. And this is where we think USCIS is wrong. You can also make the argument that USCIS is not giving full faith and credit to a final order from a state court. I've seen in a couple of RFEs and noise that USCIS says that full faith and credit doesn't apply to them, but that is incorrect. It also came up in the Budhathoki case. But there's plenty of case law that says that full faith and credit absolutely applies to agencies, not just other courts. So that argument is just flawed in terms of how USCIS is presenting it. So even if USCIS can look at the order and, sort of make this determination of whether or not the juvenile court order qualifies the child for SIJ, we still think that USCIS is incorrect in its assumption that a juvenile court in Texas can't assume jurisdiction over somebody who's 18, which is, initially what they were saying, what USCIS was saying. There's definitely provisions under state law that extend jurisdiction, and, as we already talked about them, there's things like child support, and there's even a provision for kids in foster care that extends jurisdiction. So it's definitely not a bright line rule that anybody over 18, or Texas court cannot have jurisdiction over somebody over 18 or over their care and custody. And then, finally, and this is again sort of a full faith and credit argument, but the plain language of the order clearly shows that the judge was acting, or it's more of an equity argument, that the judge was acting for the care and protection of the child in issuing its order. So those are our best arguments. Please continue making them. I think, we're probably going to have to see some additional federal litigation. It might not be on the post-18 Post-18 case issue, but it may be on other things like whether USCIS can really question, add things to its statute and regulations, such as what they're doing with the USCIS policy manual. We know that the regulations were never finalized, and it seems like they're using the policy manual to go above what their regulations state, and kind of circumventing the proper procedure in terms of letting the public comment on what their policy is going to be. So I think that's it for us. We have some questions here that we're going to go through.
One for David and one for you.
Okay, so David, we have a question for you. Let's see, it says, you mentioned that in Austin and San Antonio, they've allowed you to submit a motion to clarify. What exactly did they allow you to clarify? My understanding is that we're only allowed to clarify clerical errors, not supplement the orders themselves.
Okay, good question. The correcting a clerical area is a nunc-pro-tunc order, which is actually not what we did. We actually did a specific motion to clarify, which is they're not changing or modifying their order, they're just being more specific. So for example, and I've provided, I think Dalia and you guys have the sample motions and orders that I'm happy to share with anybody, but it says things like, yes, we asserted our jurisdiction over the child under Texas Family Code, and then spells out the specifics, whereas in the previous order it just said the child. So it was not as specific. So I should I guess clarify what Judge Sparks actually did, because Dalia, you picked up on a lot of it, which was he never said that our arguments were incorrect. In fact, he basically said he thought most of our arguments were very reasonable and that the government was way out on a limb on a lot of things. He just basically said that the orders that we had were not specific enough on certain issues, and that USCIS relied on the order to make the decision. So one of the things we're appealing is, no, they relied on the order, but they also had things like the petition, which spelled out the section of the Family Code. But that being aside, we have we clarified that the specific statute of the Family Code that they were defined as children, that they asserted jurisdiction over that section, and that they were dependent and how under the Texas Family Code, and that has varied from judge to judge. But we have argued common usage, and that was one that was granted by San Antonio. The Austin or Travis County judges cited to the Texas Education Code. So the pursuing the fact that they were in a program that qualified under the Texas Education Code, pursuing a high school diploma, is how they were then declared dependent on the court. And what else did we do? Oh, that the order of child support was indeed intended to be relief from parental neglect. Which again, all of these things are fairly clear in our petition. And USCIS did in fact have the petition when they made their decision, but Sparks did not. He basically said the order themselves didn't address these things, and that's why it wasn't unreasonable for USCIS to deny. So that's the difference with the motion to clarify as opposed to the nunc-pro-tunc motion.
And the motion to clarify is under the enforcement chapter of the Family Code, so you can find it at 157.001. So I think it's specific to, or clarifying a non-specific order actually is at 157.421. But I think the enforcement provisions are specific to child support. Is that right, David?
I believe so. I'm not the family law attorney, so.
Oh, great. So I think that's what Tanya said at your presentation, but I believe that if you want to get a clarification motion, then that would have to be tied to a child support order.
Correct.
Let's see. We have another question. It's a little more broad than Post-18. So we have seen a trend in Harris County where family courts are questioning paternity and not accepting birth certificates as proof of who the parents are in cases where children are not married. We do have a presentation that we did at our in-person CLE on January 27th, and we're going to have those. We're going to have that presentation uploaded to our website very soon. So we did touch on that with a family law expert in that presentation. So you can go to within the next week you can go to our website and view that presentation. Does anybody have any other questions?
The conference has been unmuted. The conference has been unmuted. The conference has been muted.
Yeah, sorry about that. We didn't mean to do that. Any other questions? Please type it into the chat box if you have anything else. And thank you so much, David, for coming on to the webinar. We really appreciate your time in discussing, Budhathoki and what you guys have done after. All right, so it seems like nobody has any questions. We've answered everybody's questions through our presentation. We hope you guys have a good weekend, and of course, please reach out to us at CILA if you have any further questions on Post-18 cases as things come up. Thank you, everyone. And here's our contact information. And thank you. We appreciate it.